The dangerous lesson of Trump's $1.776 billion anti-weaponization fund is not merely that a president may try to turn public money into private political tribute. That part is obvious enough. The deeper lesson is that constitutional safeguards do not usually collapse all at once. They are softened, rationalized, proceduralized, and delegated away in the name of efficiency. Then, when someone finally uses the shortcut for its natural purpose, everyone acts shocked that the shortcut bypasses the road. That is what the Federal Judgment Fund teaches. The Justice Department announced on May 18, 2026, that as part of a settlement in President Donald J. Trump versus the Internal Revenue Service, the Attorney General had established an anti-weaponization fund to hear and redress claims by others who allegedly suffered weaponization and lawfare. The Department of Justice described the fund as part of the settlement of Trump's IRS lawsuit. Reporting by several outlets says the fund is worth $1.776 billion and is to be paid through the Federal Judgment Fund, the permanent Treasury appropriation normally used to pay certain judgments and settlements against the United States. That arrangement is scandalous on its own terms. A president sues his own government, his own Justice Department settles, and the result is a massive fund that may benefit his political allies, while he receives a formal apology and avoids a direct personal cash payment. According to the Associated Press, Acting Attorney General Todd Blanche defended the fund before a Senate Appropriations Subcommittee on May 19, 2026, while lawmakers criticized it as an abuse of taxpayer money for partisan purposes. But focusing only on Trump risks missing the larger constitutional failure. Trump did not invent the underlying vulnerability, he exploited it. The constitutional starting point is sovereign immunity. The United States, as sovereign, cannot be sued unless it consents. That rule is often treated as a technical doctrine, but it carries a large constitutional meaning. It means that courts do not automatically sit in judgment over the public fisc the way they do over a private defendant's bank account. Before citizens can sue the federal government, Congress must decide whether the government may be sued, under what causes of action, in what form, and subject to what limits. That is the first gate. The second gate is appropriations. Even when the United States may be sued, money still cannot be drawn from the Treasury unless Congress has appropriated it. Article 1's power of the purse is not a bookkeeping formality. It is one of the central mechanisms of Republican government. The question is not simply whether someone has been injured. The question is whether the American people, through their representatives, will pay. Those two gates once forced a political judgment. If a claimant had a grievance against the United States, Congress had to confront it. Congress could waive immunity. Congress could refuse. Congress could authorize litigation. Congress could appropriate money. Congress could impose conditions. Congress could say, in public, the taxpayers should pay this claim or they should not. That was cumbersome. It was inefficient. It exposed legislators to criticism. It required members of Congress to take responsibility for particular claims, particular plaintiffs, and particular amounts of money. So Congress did what modern Congresses often do when constitutional responsibility becomes uncomfortable. It generalized the decision and moved it out of view. In 1956, Congress created what became the Judgment Fund, a permanent, indefinite appropriation to pay qualifying judgments and settlements against the United States. The statute now provides that necessary amounts are appropriated to pay final judgments, awards, compromise settlements, interest, and costs when certain conditions are satisfied, including that payment is not otherwise provided for and is certified by Treasury. Treasury's own explanation says the fund was intended to eliminate the procedural burden of getting a separate congressional appropriation for each particular judgment and to allow prompt payment, reducing interest where interest is authorized. That explanation is true, but it is not innocent. To say the fund eliminates the burden of obtaining a separate appropriation is to say it eliminates the moment of political accountability. It means Congress no longer has to decide, case by case, whether a particular claim should be paid by the public. It means the key decision migrates from Congress to executive branch litigators, agency officials, Treasury certifiers, and settlement documents. It means public money can move, not because Congress publicly approved the particular payment, but because officials characterize the payment as fitting within a pre-existing statutory category. The judgment fund is therefore a constitutional compromise. It makes broad waivers of sovereign immunity practically enforceable. It ensures that people who obtain valid judgments against the United States are not left holding symbolic paper. It prevents Congress from using delay or inaction to stiff successful claimants. Those are real benefits. But the compromise has a moral cost. Once Congress creates a permanent, uncapped fund for judgments and settlements, it changes the character of liability against the United States. What used to require a politically visible act becomes an administrative consequence. What used to require Congress to say, yes, taxpayers should pay, this person becomes a legal classification question. Is there a final judgment? Is there a compromise settlement? Is payment otherwise provided for? Would the underlying judgment be payable from the fund? Treasury regulations capture the breadth of the mechanism. The judgment fund is available to pay many judicially and administratively ordered monetary awards against the United States, and amounts owed under DOJ negotiated compromise agreements in actual or imminent litigation are normally paid from it if a judgment on the merits would be payable from the fund. That last sentence is where the danger lives. Compromise agreements negotiated by DOJ. A court judgment at least has been tested through adjudication. A settlement is different. A settlement is a prediction, a bargain, a risk calculation, and sometimes a policy choice. When the defendant is the United States, a settlement is also a spending decision. The executive branch is deciding that public money should be used to extinguish a claim. Usually, that may be sensible. Litigation is expensive. The government can be wrong. Injured people should be compensated. No serious system can require a full congressional vote every time a mail truck hits someone's car or a federal agency breaches a contract. But the constitutional problem is not ordinary cases. The constitutional problem is the edge case that reveals the system's true nature. Trump's so-called anti-weaponization fund is now the edge case that everyone's talking about. If the fund just paid a valid, individualized legal liability to a plaintiff whose claim Congress had actually authorized and whose damages were legally cognizable, the controversy would still be politically ugly, sure, but it would be structurally familiar. But here's the thing. The reported arrangement seems to do something far more troubling. It uses the settlement of Trump's own lawsuit as a vehicle for creating a huge compensation process for other folks who claim political mistreatment. Time reported that the Department of Justice said the fund would receive $1.776 billion from the judgment fund, and it would be overseen by a 5-member commission appointed by the Attorney General, with 1 member selected in consultation with congressional leadership. The Guardian reported that critics have attacked the arrangement as potentially unconstitutional and as a slush fund-like mechanism to compensate Trump allies. That, right there, is the critical line. The judgment fund is supposed to pay legal obligations of the United States, plain and simple. It's not meant to become a president's discretionary reparations program for political loyalists. If the executive can settle a friendly lawsuit by creating a fund for non-parties, political allies, or ideologically favored claimants, then the settlement form has just swallowed the appropriations function. The issue here isn't just corruption in the narrow criminal sense. It's what you might call constitutional laundering. The executive takes a political spending program that Congress hasn't enacted, dresses that program up as a litigation settlement, and then invokes a permanent appropriation that Congress created for judgments and compromise settlements. Treasury pays out. Congress complains after the fact, and the public is told that the money moved legally because supposedly the right procedural boxes were checked. That is why congressional outrage, however justified in the immediate case, has an element of self-indictment. Congress built the bypass. Congress chose not to vote on individual payments. Congress chose not to force agencies to bear the cost in their own appropriations in every case. Congress chose not to impose narrow, case-specific limits on every settlement. Congress chose a permanent and indefinite appropriation because the alternative was difficult, slow, and politically exposed. Now, the complaint is that an executive has discovered what such a structure can do. That does not excuse Trump. It actually condemns the system that made his maneuver plausible. A constitutional check is not a slogan. It is a burden. Congress's power of the purse matters only if Congress is willing to use it. Sovereign immunity matters only if Congress treats waiver as a grave decision rather than just a housekeeping matter. Appropriations matter only if they force politically accountable judgment about who gets public money and why. When Congress delegates those decisions away because they are tedious or controversial, it does not abolish politics. It hides politics inside legal administration. It tells the public that payment is now technical, not moral, procedural, not political. But the moral question remains exactly where it always was. Should taxpayers pay this claim? The Judgment Fund answers that question in advance, in a move that directly contravenes the Constitution, ignoring the processes established for its proper amendment. You cannot remove the check and expect the balance to hold. Congress cannot preserve the power of the purse by delegating away the very judgment that gives the power meaning. The Constitution does not assign Congress a ceremonial role in public spending. It requires Congress to decide whether money shall be drawn from the Treasury. That decision cannot be converted into a permanent administrative reflex without altering the constitutional structure itself. The defenders of the Judgment Fund will call this efficiency. But efficiency is often the language institutions use when they want to escape responsibility. It was inefficient for Congress to consider individual claims. It was politically uncomfortable to decide whether taxpayers should pay for particular governmental wrongs. It was administratively burdensome to confront the moral facts of each case. So Congress invented a mechanism by which those decisions could be made elsewhere, later, and under the appearance of legal necessity. That is the evasion. The Judgment Fund does not merely pay claims. It changes who decides. It takes a question the Constitution assigns to Congress and hands it to executive actors, agency lawyers, settlement negotiators, and Treasury certifiers. It allows the government to say, the law requires this payment, while concealing the prior abdication that made the payment automatic. The real constitutional question, whether the people's money should be used for this purpose, has already been removed from public view. That removal is the moral compromise from which the later corruption follows. A republic cannot maintain checks and balances by suspending them whenever they are inconvenient. The check is the inconvenience. The burden is the safeguard. The requirement that Congress vote, explain itself, and accept political responsibility is not a procedural nuisance. It is the constitutional design. Once Congress creates a standing, indefinite, effectively open-ended appropriation for judgments and settlements, it creates a reservoir of money waiting for an executive theory. The only remaining barrier is characterization. If the executive can frame a payment as a judgment, a settlement, a compromise, or an ancillary fund connected to litigation, the constitutional fight has already been displaced from the public legislative arena into the technical language of eligibility. That is how abuse becomes predictable. Trump's anti-weaponization fund is not an aberration from the logic of the Judgment Fund. It is the logic of the Judgment Fund carried to its corrupt conclusion. Once Congress establishes a mechanism that allows public money to move without case-specific legislative approval, it should not be surprised when an ambitious executive uses that mechanism to reward friends, punish enemies, manufacture victims, or convert political grievance into payable legal claim. The monster did not break through the door. Congress opened it. The answer, then, is not better guidance, cleaner forms, more careful certification, or a sternly worded oversight letter after the money has moved. Those are managerial responses to a constitutional violation. They treat the abuse as a defect in administration rather than the predictable consequence of abdication. The Judgment Fund must be abolished. If the United States is liable, Congress should say so. If taxpayers are to pay, Congress should vote. If a judgment or settlement deserves public money, the representatives of the public should bear the political responsibility for appropriating it. That responsibility cannot be laundered through a permanent fund without converting the power of the purse into an executive convenience. Congress may waive sovereign immunity. Congress may create causes of action. Congress may authorize courts to hear claims against the United States, But when the time comes to draw money from the Treasury, Congress must not hide behind its own prior delegation. It must decide. If Congress refuses to abolish the Judgment Fund after seeing it used as a vehicle for political patronage, then Congress is no longer merely negligent. It is abetting the scheme. It has been shown the danger. It has seen how the mechanism can be weaponized. Continued acquiescence would amount to ratification. That is the final lesson. You cannot undermine the Constitution just a little. You cannot suspend accountability for routine cases and expect it to reappear for extraordinary ones. You cannot make an exception to the power of the purse and then act shocked when the exception becomes a treasury. You cannot remove the check and expect the balance to hold. The Judgment Fund is not a solution to constitutional difficulty. It is constitutional abrogation, and the cost is now visible.